So first, I would like to welcome His Honour Coroner Simon McGregor from the Coroners Court of Victoria. Prior to being appointed as a coroner in 2018, Simon was a member of the Victorian Bar for 21 years, and on his way there, he was President Winnicke's researcher and a Court of Appeal registrar before he read with H.A. Jake Forrest, had 6 readers of his own and 2 Indigenous lawyer mentees. He both practiced and published in administrative and human rights law, health and regulatory law, inquests, commissions, proceeds of crime, and other investigation spaces. So I'd like to welcome His Honour Coroner Simon McGregor to speak first. Thank
you. Thanks, Mark. I'd like to begin by echoing Melissa Castan's acknowledgement of the traditional owners of the land on which we gather, and I pay my respects to their elders past and present, and also to any Aboriginal people with us today. I acknowledge your presence and say thank you for continuing to share your voice with us. The caveat to my talk is that I think it's very boring, but your committee assured me it would be interesting to you. It's boring because, as the previous panel were just describing, having been a judge, having done certain cases, there's a time when everyone has to listen to the judge, and the judge has to say everything that they've got to say about a case when they publish their findings. And after that, it's the judge's time to shut up, and people will make of it what they will. Will it be appealed? What do journalists think of it? What do academics think of it? And so I need to be careful today, and this is the reason why I think it's boring, but I'm not saying to you anything that I haven't already said in a judgment. If I could have the next slide, and this is the only slide. So I'm talking with you about 2 cases where I have mapped human rights law into the coronial jurisdiction. And so just so you don't need to take too many notes, we've circulated the link to both of those cases. And that's the first case is that of Veronica Nelson, who was an Aboriginal lady who was a drug addict who failed to get bail for an offence that she would never have done any actual jail time for, and then subsequently died in custody from natural causes whilst a small army of people on the taxpayers' dollar stood around and watched. That decision, that finding is 350 pages, but there's a webcast of me reading out the finding, and it's 3.5 hours, but you can listen to it. It's in sort of 1-hour chapters. So if you like podcasts, if you prefer to take this stuff in as a listening thing rather than a reading thing, you can do that. And the second case that I'm drawing on in what I speak to you about today, mapping human rights into the coronial jurisdiction, is called the XY, which is a pseudonym case. And this is about a troubled Aboriginal teenage sex assault victim who spiralled through 10 years of the child protection system before she committed suicide. So that was a 250-page decision. So what the organisers might have achieved for you in giving me 20 minutes to talk about those is that you've got a lot of time in your life back. If all you get to is hearing 20 minutes on it from me, you can make an informed decision about whether this goes any further or not. So I would say, though, too, in the interest of time, and this is me taking a moment as a practising judge to appreciate the role of academic lawyers, I did Nelson first, and then I did XY. But in between, after Nelson, 2 academics well known in Castan Centre circles, I know Bruce Chen is here today, and Anita Mackay, wrote and published a great article analysing the Nelson decision, the human rights perspective on it. And I found that very helpful. And by the time I got around to writing XY, the discerning reader will spot, I think, some refinements and some improvements. I can say neither case, on the charter issues, neither case was appealed at the end of the day, so they both stand. But if you're only going to read one of them, thanks to Anita and Bruce, I would say read XY as a refined template, but also, isn't it great how academic and practitioners can inform and improve each other's work? So I just want to say, I think this conference today, that sort of input is a sign of the success stories. So the cases involve different rights, and with the time I've got available, I can't spend too much on the weeds, the detail, the fine print of the child protection system or the bail, remand and healthcare in prison system. You'll get all that detail in the cases, and you'll also get some extracted parts. If you just want to see how the charter mechanics work, you don't need to read all those hundreds of pages. They're in smaller pockets. But so with that out of the way, and the final caveat being a judge that I need to remind everyone of is I made those two findings based on the evidence I had and the submissions I had in those two cases. And of course, none of you will be surprised that I might decide something differently next time it happens. All I'm doing is sharing with you a template that so far hasn't been appealed. And if that's of some use to you, great. It follows, though, from how I've lent on this in both these decisions and spent a fair bit of time with the charter stuff, that in my mind, the human rights mechanisms are a very useful lens through which to view the multitude of interactions that the state and its delegates have with individuals within its jurisdiction. So what you've got to do first, and this is applicable in any jurisdiction, but in the Coroner's Court, is you've got to understand what the coroner's job is. That's just set out in the Coroners Act. And so it's very simple that I've got to establish the identity of the person, their cause of death, which is often medical, and enough background circumstances to give context to those two other pieces of information so as to allow the better administration, public health planning of the state of Victoria by having accurate information about that. Now, on the way, I'm given what's called a prevention remit. Whilst I'm making those findings, I also have a power to make comments or recommendations about matters that are connected with the death. And through those lenses, you can make comments about prevention. And there's an interesting, I think, very useful overlay there with charter mechanisms. So remember the coroner's job, and then if you're involved in a coronial proceeding, you want to map whichever source of rights documents you're using for the coroner before you get into the subject matter of the inquest. So we're lucky here in Victoria because we've got the charter, and the charter is mostly drawing on those ICCPR rights. But in my XY decision, I was also mapping from the Convention on the Rights of the Child to get to our Section 19 rights of families and children. So don't assume that your judge knows that, but map it for them and map it how it ends up in your domestic law. Right, then the processes that you're going through is, you know that the Charter tells us that all laws are to be as compatible as possible with, consistent with the human rights that are articulated in there, and it requires lawyers to read the laws that way to the extent there's an ambiguity, and it also requires Victorian public authorities to act in a way that's compatible with human rights and to give proper considerations when they're making decisions, proper consideration of human rights. So there's a few different ways then that the Charter influences the job a coroner already has to do. So that's how you map it in there for them. So say when we're looking at a particular circumstance, and what the coroner's mostly doing is finding facts about what went on, you're considering whether a death would be preventable. I will have figured out a few different human rights that I think are engaged, ask whether they are engaged in the interactions that person has with the state. If so, were there rights that you've had to think about? Were they limited at some stage? And if they were limited, were the limitations reasonable and demonstrably justified by some evidence, or whether there were alternative pathways that were available that were more effectively balanced the rights and the limits? So it's that alternative pathways element that really resonates with me as a coroner when I'm exploring a prevention opportunity. So I've done some fact finding, something hasn't worked. Is there a better way it could have been done? One way it might be better. It may be more efficient to do it some other way, or it might be better in terms of its human rights compatibility. So there's a nice fit there with a jurisdictional task that I'm doing anyway. So then the Charter influences the law in Victoria by applying to all courts and some of the tasks that they do as courts. It then applies to all public authorities, and most courts aren't very public authority-ish, but because the coroners, or we're inquisitorial, and 90% of what we do is investigative, we're often a public authority. So it applies to the Coroner's Court that way, and then it also applies on the subject matter of the death that we're investigating, whether it's a death in care or a death in custody. So there, you might, in many cases, all three roads lead to Rome that the Charter applies. So I'm going to do consider the rights and step through the process that the Victorian Supreme Court's explained to us. But it is good to have turned your mind to which road to Rome am I on, because sometimes that might affect the outcome. So then, when we're looking at, say, the actions of public authorities, which includes private companies that are contracted to fulfil government tasks, the Supreme Court in the Certain Children No. 2 case gave us a great little template of what to apply. So this is when you've got your subject matter, and you then, what I do to remind myself of the machinery of the Charter, I get Kylie Evans and Alistair Pound's great book out. I go through that for the machinery. Then I'm looking for the detail of this right and that right. And then I love looking at Sarah Joseph and Melissa Castan's great ICCPR book. You get all that stuff ready. And then you step through this analytical exercise yourself. And then it gives you some insight into how that's rights working in relation to your subject matter. So from Certain Children, the first thing we do is figure out, is any human right relevant to the decision or action that a public authority has made, taken, proposed to take, or failed to take? We call that the relevance or engagement question. If so, has the public authority done or failed to do anything that limits rights? The limitation question. If so, is that limit under law reasonable and demonstrably justified, having regard to the matters set out in the proportionality test in the Charter? We call that the proportionality or justification question. Even if the limit is reasonable and demonstrably justified, if the public authority has made a decision, did it give proper consideration to the right? So that's the proper consideration question. And finally, was the act or decision made under the act or the instrument that gave the public authority no discretion in relation to what to do? Or does the act confer a discretion that cannot be interpreted under the Charter in a way that is consistent with a protected right? That's called the inevitable infringement question. It's effectively a defence to say I couldn't do it any other way while still respecting the Parliament that created these laws. So there's substantive obligation in there, a procedural obligation, and if either of them are not met, you have unlawfulness under the Charter, you have a right not being appropriately articulated, and then what you will do in that process, when you get to the remedies, the relief, the consequences of finding a charter right not being respected, is there's an interesting quote that I think just the eminent Justice Weinberg put it best when he said in the Sudi case, which was about public housing, he said, it's one thing to characterise non-compliance as unlawful, and that's an easy thing for a coroner to do as you go through finding facts and using the Certain Children analysis. It's quite another to determine what sanctions or remedies might be available. So you need to then come back to the job that your judicial officer is doing. If it's a coroner, I'm finding identity, cause of death, background, circumstances. I can make comments or recommendations in connection with the death. So it's a drafting exercise to think, where are we getting to? How can we articulate that? So as an example, in the XY decision, one of my conclusions was, so we're thinking about the actions of the department, and in relation to this child, there was a family reunification order in place from the Children's Court, and the department had not acted on that order. So I've said, as we go through all that evidence, To sum up, these two failures by the department to actively consider XY's views about her own best interests, that's the rights of the child, constitute an unjustified and disproportionate limitation of XY's charter right to the protection of her best interests as a child, and thereby constitute unlawfulness under section 38(1) of the Charter because the department acted in a way that was incompatible with her right. There's no demonstrable justification here because the attempts or failures to action her voice were not documented by the department. Nor are there any reasonable rationales for not pursuing the sibling access recorded. These are disproportionate because without access to or the hope of obtaining the quality of life that XY herself articulated, far greater resources were continually expended by the department as she lurched from crisis to crisis without a long-term solution in sight. So that's a drafting exercise. I really just used the language of the Charter in reaching the conclusion on the facts. There's no relief that arises out of that. But I have the power to make findings at recommendations. I can't force anyone to do anything, but you have to respond to my recommendation, and that's published. So effectively it creates an accountability footprint, and that either is, if it happens again, you can't say you didn't think of that, and it might then impact government decisions about funding, hiring, media reporting, voting, all that sort of stuff. So it creates an accountability footprint, even though I can't make anyone do anything. So some of the stuff in Nelson, some of the charter type findings were during the bail hearing, I find that the advocate failed to properly consider Veronica's charter rights in that her Aboriginality was not actively asserted in the bail hearing, and that would have put her into a favourable bail category, so she wouldn't have gone to jail. Once she got to jail, they knew she was withdrawing from heroin, but there was a policy at the time that there was no opioid substitution available in jail, even though that is available in the community. So under your right to equality in the Charter, she wasn't getting equivalent health care in prison as she would have got out in the community. So I found that the opioid guidelines infringe prisoners' rights to be treated humanely whilst deprived of liberty and their right to life, given the greater risk of a fatal overdose upon release to society, and that's contrary to section 22 and section 9 of the Charter. And I also found that the treatment she received constituted cruel and inhumane treatment, contrary to section 10 of the Charter. So then you can, as you go through essentially a fact-finding exercise, you can reach some conclusions on those facts that is the wording the Charter uses. You're not invoking, it's not a declaration of inconsistent interpretation, that's a Supreme Court constitutional remedy, but it's a fact-finding process. It's a way of summarising those in a pithy way that both lawyers understand and the community understands. And I think I second guess that one of the reasons we're able to alter temporarily the bail laws in Nelson and alter permanently the opioid policies within the jail was the amount of that it was well understood at a common sense level what was wrong here. And that's that challenge of creating, I liked Hugh de Cresta's concept of the policy window, of creating enough interest, which means enough eyeballs, enough votes, to show in plain English why something could be done a lot better, and then to make this comment or recommendation. I'm not making anyone do anything, but it's up to them whether they do or don't. So, so that's your process, and that's the template that I've applied with the help of the people at the bar table and the submissions that I had in both of these. Nelson was appealed, not on the Charter point, and unsuccessfully appealed, and XY wasn't appealed at all. So there's about 600 pages worth of reading up there. If in 15 or 20 minutes here I've saved you some time, it's allowed you to do something great like come to this conference, or who knows how we can all make the world a better place. But for me, that's the utility of this process, is that the reality of human interactions are very complicated and incoherent, and they're a mixture of competing priorities. And for instance, in XY, I read 40,000 pages of child protection notes to try and make sense of that. Human rights analysis provides a lens, a filter through which to remind ourselves what's important, why we're here, and given the coroner's prevention remit, it gives us an opportunity to articulate a better world. Thanks for your attention.